Big news from Supreme Court as the apex court on Wednesday stayed an Allahabad High Court order which said that grabbing breasts and breaking the strings of the girl's pyjamas while dragging her under a culvert were not sufficient to hold the charges of rape or attempt to rape. Yes, you heard right. There was an order by High Court which said that. However, Supreme Court has come to the rescue and a bench of Justices B.R. Gawai and A.G. Masih said, and I quote, "We are at pains to say that some of the observations made in the impugned order depict a total lack of sensitivity on the part of the author of the judgment." The top court had registered a suo motu case in this regard on Tuesday. The order noted that the March 17 judgment was not authored at the spur of the moment but was pronounced after being reserved for 4 months, indicating application of mind by the judge concerned. The bench said that since the concerned observations are totally unknown to the tenets of law and depict total insensitivity and inhuman approach, we are inclined to stay those. The top court issued notice to the centre, the state of Uttar Pradesh, and the parties in the matter before the High Court. It also sought the assistance of the Solicitor General in the matter.
जी, इलाहाबाद हाई कोर्ट की जो जजमेंट है 17 मार्च 2025 की, जिसमें हाई कोर्ट ने विटल डाउन करी हैं धाराएं जो कि 376 ऑफ आईपीसी रेड विथ 511 रेप अटेम्प्ट टू रेप की धाराएं लगी थी, उनको इलाहाबाद हाई कोर्ट ने वाटर डाउन करके विटल डाउन करके सेक्शन 910 ऑफ पॉक्सो लगाया है, जो कि एग्रेवेटेड सेक्सुअल असॉल्ट की धाराएं हैं। सुप्रीम कोर्ट में ये आज ये सुओ मोटो सुप्रीम कोर्ट ने कॉग्निजेंस लिया, क्योंकि इस तरह की इलाहाबाद हाई कोर्ट की जजमेंट के काफी रैमिफिकेशंस हैं, बिकॉज इंटरप्रिटेशन बहुत ही नैरो हो गई है ऐसे केसेस में, ऐसे इंसिडेंट्स में वेयर इट इज एविडेंट दैट द माइनर गर्ल जो लड़की है उसको खींच के एक कोने में ले जाया जा रहा है, उसके ब्रेस्ट को प्रेस करा जा रहा है, उसके लोअर गारमेंट का नाड़ा तोड़ा जा रहा है, और फिर भी उसको अटेम्प्ट टू रेप नहीं माना गया है। तो सुप्रीम कोर्ट ने सुओ मोटो कॉग्निजेंस लिया और सुप्रीम कोर्ट ने आज कहा कि ये बहुत ही इनसेंसिटिव ऑब्जर्वेशन थी इलाहाबाद हाई कोर्ट की, और उस पर अभी स्टे लगा दिया गया है, और सुप्रीम कोर्ट ने इसमें नोटिस भी इशू कर दिया है यूनियन ऑफ इंडिया को, उन्होंने एक्सेप्ट भी कर लिया है नोटिस। तो बाकी आप डिटेल ऑर्डर।
विक्टिम की मदर भी मैम अप्रोच किया है सुप्रीम कोर्ट?
जी, विक्टिम की मदर को हम रिप्रेजेंट कर रहे हैं सुप्रीम कोर्ट में, तो हम अब इम्प्लीमेंट इसमें लगा देंगे, तो हमने ऑब्जर्वेशन कोर्ट के आगे रखा।
Observations have been made by the court as far as this case is concerned.
Okay. So, the Honorable Supreme Court observed that the observations made by the Allahabad High Court by its impugned order 17th March 2025 were completely insensitive, and considering the facts of the case, there was no reason why it was not an attempt to rape, and that is why the Supreme Court said that the observations were completely insensitive, and the Supreme Court has already stayed the impugned judgment of 17th March 2025.
Now let's understand the case in question. In January 2022, a woman had filed an application in a POCSO court in Kasganj in Uttar Pradesh seeking direction to the police to register an FIR against 3 men for rape and criminal intimidation. Now, in her application, the woman alleged that while returning to her village with her daughter on November 10, 2021, 2 youths from her village offered to drop her daughter home on a motorbike. She said that since they were from her village, she allowed them to drop her daughter. On the way, the woman alleged one of them grabbed her daughter's breasts while the other tore the strings of her pajamas while dragging her under a culvert. Now, meanwhile, 2 men from the village who were passing by a tractor allegedly heard the screams of her daughter and reached the spot. The 2 youths fled and threatened the 2 men by aiming firearms at them, she alleged. Now, according to the woman, the father of one of the accused threatened to kill her when she complained to him about the sexual assault on her daughter. She approached the local police the next day, but no action was taken. The Kasganj court treated the woman's application as a complaint and ordered the police to register a case on March 21. The court recorded the statements of the complainant and a witness. During the proceedings, the court summoned the two youths under Indian Penal Code, Section 376, that is of rape, and Section 18 of the POCSO Act, which is of attempting to commit offence. The father of one of the accused was summoned under IPC sections 504, intentional insult to provoke breach of peace, and 506, criminal intimidation. Now, the three accused then approached the High Court challenging the POCSO court's summons. Their counsel argued that both the families are rivals and the rape allegations were to settle scores. The counsel also told the High Court that the mother of one of the accused had lodged a case against 4 people on October 17, 2021, alleging molestation when she had gone to her farm for work. One of the 4 accused named in that case is the uncle of the minor girl, the counsel claimed. Accusing the mother of the minor girl of cooking up the rape story, the counsel of the accused told the High Court that it was beyond belief that she would send her daughter with the youths belonging to the family, which has lodged a case against her brother-in-law. Hearing the petition challenging the summons, a single judge bench of the Allahabad High Court ordered that the offence of rape in the case be altered into that of assaulting or abusing with an intent to disrobe or compel her to be naked. The High Court then directed the trial court in Kasganj to issue fresh summons to the 2 accused who had been booked for rape under the modified charges. The order said that this court finds the finding of the learned court below with regard to the offence of attempt to rape in the impugned summoning order is not sustainable, and instead they are liable to be summoned for minor offence under sections 354B IPC, read with section 910,